Hello and welcome to the Portage County Financial Wellness Fair virtually this year. My name is Attorney Mike Dailey, and I'd like to thank you for taking some time out of your day today or your week for watching some of these presentations. I certainly encourage you to watch all of them. Move through this. I am Attorney Mike Dailey. I practice right here in Ravenna, Ohio. I've been here for 7 years. I'm a general practitioner. A large portion of my practice includes guardianships, probate, estate planning, and so I run the gamut of power of attorneys, guardianships, last wills and testaments, powers of attorneys, transfers on death. And so, what I'm here to do today is to help everybody with the important topic of guardianships and powers of attorney. And the number one question I get from people is, well, I already have a will. I'm okay, aren't I? And that is one of the biggest misnomers is people think, well, I have a will. That last will and testament says what I want to have happen to my property. And that necessarily isn't always, the case. And quite honestly, it's usually not the case if all you have is a will. Most people, they give me a call and they're like, hey, Mike, I want to come in and draft a will. That is literally the phone call that I get from most people is, I need a will. They just assume that's what they always see on TV. I need a will, and then they come in and then we sit down and we start talking, and the answer is, well, we need to talk about it, because one of the things you'll find out is, like I said, I do a lot of estate planning. And, a lot of people think that deals mostly with, one of two categories. There's, at least I believe, estate planning involves while you're alive and after you pass away. Most people think about that second category there, where, like I said, you have your last will and testament, you have your trust, you have transfers on death, you have payable on death for bank accounts. There's a whole other presentation from another presenter coming up on the issues of, after you pass away. What we're here really to talk about today is, while you're alive. And that includes guardianships, powers of attorney, living wills, and documents like that. And so, a lot of people go, well, I just want a will. So why are guardianships and powers of attorneys important to me? Well, the goal of all estate planning is the management and transfer of assets and debts. So, when you're dealing here, that's why it's really, really important not only to worry about who gets your assets after you pass away, but it also is very important, and I think more important, to worry about, how are my assets and debts going to be managed if I'm unable to? Because that's really the question here, is that, if I'm not able to make a decision, whether it involves paying a bill or, deciding what doctor I'm going to go to, that's going to be somebody else. And so that's why they're so important. It's all about you and while you're alive. And so you have to decide, who's going to make those decisions for you. And so that's why it's so, so important to talk about these issues now. And the other thing I hear from people is, Mike, I'm 30 years old, 40 years old, I'm in reasonably good health, and I don't need a power of attorney. Nobody needs to be making decisions for me. And what I tell people is this is actually the right time to start asking, about guardianships, powers of attorney, and other estate planning. I tend to see people, come in here, they'll call on behalf of mom or dad and go, mom's in the hospital, she just had a stroke, I need a power of attorney for her. And, what, I have to tell people is, I'm like, well, is mom awake? Is mom able to make decisions for her? Or, mom has dementia, I need a power of attorney for her. And at those point in time, I have to say, no, I'm sorry, I can't help you with it, because, at that point, you have to have somebody who is mentally capable or physically able to do a power of attorney. And in a lot of those cases, the answer is it's too late. So what I tell people, the great thing is to have these conversations now about guardianships, powers of attorney, and they can change through over the years. That's one of the great things we'll talk about today with powers of attorney is that your situation today probably won't be the same situation you'll have in 20 years, especially if you're a younger person, 30, 40 years old. It may not change a whole heck of a lot if you're 60 or 70 years old. But the great thing is you want to have the conversations now, so you have the flexibility to make decisions and make changes, and handle situations that come up, that you may not be expecting. So the to get a handle on, okay, which is right for me. Guardianships, powers of attorney, I've heard about them. I don't know a whole heck of a lot about either one of them. I know I should have one or the other. I feel the best way to decide which one's right for you is let's kind of get an overview of what each of them are and what each of them does. So here in Ohio, just like when you watch the other presentation on estate planning, is that there's court involved way and there's not a court involved way. So that's really what it boils down to. And so guardianships, as you see my judge sitting there, is the court involved way. So what we have here is that it is created by statute. It's overseen by the probate court. It is a common pleas court. The probate court judge is seen as what's called a superior guardian. It's generally an involuntary process that you go through. And when I say involuntary, it's usually not done by the volition of the person who it's going to benefit, the ward. So in this process, what you have is you have a guardian who is the person making decisions, and then you have a ward who is generally the person for whom decisions are being made. Like I said, generally it is not the ward who is making this decision. It's not usually the ward who is petitioning the court to open a guardianship. And once it is established, it takes effect immediately. And so as we kind of get it a little farther into powers of attorney, that may be a major, consideration in there, is that it takes effect immediately, where powers of attorney sometimes take effect immediately. And so we have two types of guardianships that we deal with, on top of that. So there are guardianships of the estate and guardianships of the person. One can exist, both can exist. Every situation is different. So guardianships of the estate deal with paying bills, buying and selling assets like your house, your car, living arrangements. Guardianships of the person deal more with health care, medical decisions, those types of things, and also living arrangements. Wait, I have living arrangements on there twice. So here's one of the crazy things about guardianships is that you definitely want to have the same person making both decisions. You can theoretically have one guardian for the estate, one guardian for the person, but with living arrangements, the guardian of the person can say, I want grandma to live here. But then if the guardian of the estate says, I'm not paying for grandma to live there, you can have some discord. So I generally recommend that people work together, or there only be one guardian. Typical situations where you see only one or the other, typically is where somebody's only receiving Social Security or something like that, and you have what's called a Social Security payee who is receiving the financial benefits. It's usually a nursing home or a hospital, and so therefore you only need a guardianship of the person. So guardianships are a court process. So, which means that court processes are generally adversarial in nature, meaning that it's one person versus another. And when you're dealing with a guardianship, you're really dealing with taking away somebody's rights and putting somebody else in charge to make decisions for that person. So it is a major court decision that has to be made by the judge. And so, like any court process, there has to start with, in normal civil court, you have what's called a complaint. In the guardianship process, you have an application. Now, depending on your situation, You may have, expedited applications because there's an emergency or something like that. But generally, it's a fairly slow process to make sure that the ward, and their rights are protected. That's really the goal here. So usually the applicant is the person who is applying to be the guardian. So whether that be a spouse, son, daughter, niece, nephew, I'm a guardian of a ward. There are attorneys who are appointed. So it all depends on who is going to be the applicant. And so the applicant has to say first that I believe that this person is unable to make decisions for themselves. That's the first question for a guardianship. Generally, you don't open guardianships for people who can make their own decisions. So that's the first thing that the court looks at. And so the way to determine whether or not the person can make their own decisions is generally there's what's called an expert evaluation. That is usually completed by the primary care physician who has probably been in contact with a son or a daughter who has been taking them back and forth to the doctor's office or whatever it may be. But you have to have a doctor who's willing to say, I don't think this person can make decisions on their own. And then the next question is once the applicant has proven or had somebody testify that they cannot make decisions on their own, it's what's called the least restrictive alternative. You may say, whoa, by this time there's stuff that's been filed, and of course, there's no other alternative. But I've actually seen a lot of litigation in this, generally where there was a power of attorney at some point in time, and maybe, one sibling is the power of attorney for mom or dad, but the other sibling doesn't feel that the sibling is doing what's in the best interest of mom or dad. Or maybe mom or dad only did a healthcare power of attorney and didn't do a financial power of attorney. So you have to look and say, okay, is this the least restrictive alternative? And so if somebody comes forward and says, whoa, I have a power of attorney for mom or dad or whoever it may be, and I'm acting in the person's best interest, yes, this person may need somebody to make decisions on their behalf, but I can do it, and the least restrictive alternative is my power of attorney that I have here. Because like I said, it is, an extreme power of the court to say, you can't make your own decisions. So the court's going to look at all of this before saying, okay, we're going to give somebody this power. And like I said, once you've gotten there, there's a court hearing. And you can have competing applications between different children. And it can cause a lot of stress between siblings. It can actually cause stress between parents and children. Because this is a court proceeding and you're affecting the rights of the ward potentially, the ward is actually entitled to appointed counsel at no cost. So, I have served in that capacity, and it's a very interesting role because there are times where it's clear that the person needs the assistance, where you maybe had somebody who suffered a stroke or is got severe dementia or something like that, where it's clear that you're there just to make sure that the best interest of your client is being taken care of. But then there are other cases where maybe a son or a daughter is concerned about how mom or dad are spending their money, and they don't like, what's going on. So they're filing this, and then you have mom or dad who's like, I want to enjoy my money. I want to enjoy my retirement, and yeah, I may be spending it, but I'm doing it because that's what I want to. And so it can actually get very, very contested and very adversarial, at times. So you need to be prepared for that. And along with that, so unlike most court hearings where you have a trial, and once the trial is over and the court has made its decision, you're done. Well, not in a guardianship. Actually, guardianships can go on for decades. You typically see that in cases where you have a guardianship opened for somebody who has disabilities. It's usually a parent who opens that guardianship. And the guardianships last as long as they are needed. And generally, that's the lifetime the remaining lifetime of the ward. So, every year, because there's a lot of court oversight, you have to file annual reports for both health and finances. You have to get court orders to pay bills and different things like that. So it is heavily court involved. One of the things, because there's so much court involvement, is that there's not a whole lot of change. There's a lot of rigidity in guardianships. Once we have a guardian, that's the guardian. And, good, bad, or indifferent, unless somebody else comes along and says, hey, I don't think this guardian is doing something in the best interest. Or, more typically, the current guardian has passed away or physically or, unable to, continue to fulfill that role. And so, generally, once we have a guardian, that's the guardian, from here on out. So that kind of is a basic overview of guardianship. So now I kind of want to talk about powers of attorney. So they're also statutorily created. The big difference here is there's little to no court oversight or involvement. So, like I said, generally, what happens is somebody comes into my office and says, Mike, I want to create a power of attorney. So they're voluntary. And when I say voluntary, I mean that, you come into my office and you say, I want to set this up. I want to choose who is going to make decisions for me. And one of the big things about that is that it may or may not take effect immediately. So, what we typically see here is that you usually have, like spouses, they typically are not as concerned about when a power of attorney takes effect. But generally, when I see one parent come in here after the other one has passed away, they usually like to retain their independence. And so they may not want their powers of attorney to take effect. But on the other hand, I had a lady once who was perfectly fine. She was probably in her mid-60s or so. And she said, Mike, I'm perfectly fine, and I want to enjoy my retirement. So I want my financial power of attorney to take effect immediately. And I want my son to pay all my bills for me because I just don't want to. And we can set that up. So that's something you need to talk about with your attorneys. We can set them up so that they only take effect when your doctor says you're not able to make decisions, or we can set them up to take effect immediately because you trust your kids, or your wife, or your husband, and it's fine. But again, like I said, there's very little court oversight or involvement. With powers of attorney, you can change them all the time. I definitely encourage people to come in and talk about them early on. So, like I was saying earlier, what may be the right power of attorney when you're 30 is probably not the right power of attorney for you when you're 70. So it's important that when you create these powers of attorney, that you update them on a regular basis. Does that mean you have to come in once a year? In a perfect world, I guess. But, every couple of years, take a step back and see, where are you at, personally? Did you get married? Did you get divorced? Have you had children? Are your children now grown and out of the home? So do we need to change that? Has your power of attorney, moved? Is your power of attorney still alive? Have they had, major changes in their lives? You may not want a power of attorney, who's had a bankruptcy or been convicted of a crime. And that's one of the things you have to look at, is that because there's very little court oversight or involvement, is that the decision is up to you. If the court is approving a guardian, the court is going to do a background check. And the court is going to see, okay, if this person has a lot of bankruptcies or has a bunch of felonies, that may not be the person the court appoints. But with a power of attorney, that's your choice. And you decide, who that person is. Now, they're bound by what's called a fiduciary duty to do what's in your best interest, but that is a back-end remedy. So, what can happen there is that your power of attorney could face civil sanctions. They could possibly face criminal sanctions if they don't do what's in your best interest, but it's all on the back end. And so that's something you really got to think about, is if you give John Smith financial power of attorney over you, and John Smith writes a check to themselves for all the money in your bank account, that money may not be there, when you realize that it's gone. Or in the worst case scenario, maybe you're not in a position anymore to oversee all of that, and it may not be till much later that somebody realizes that something was wrong, and that money may not be recoverable at that point. So when you're choosing a power of attorney, it's a very important decision that you have to slowly make. So just like with guardianships, there are two types of powers of attorney. There are financial and there are healthcare and living wills. So the financial are pretty straightforward. It's just like guardianship of the estate. They allow you to pay bills, buy and sell assets, manage bank accounts, and also living arrangements. Same thing. Healthcare deals more with, what doctors you're going to go to, routine medical care, surgeries, those type of things. Living wills tend to be more end-of-life decisions, but they can also include living arrangements as well. And the same thing, just like with guardianships, one of the big problems I see people have is that they have two kids and they love both kids to death, and they could not possibly choose Billy over Sally, and they want Billy for finances and they want Sally for health care. And what can happen with that last one, the living arrangements, just like I was saying earlier, is if Sally wants to put mom in place X to live, but Billy says, listen, we can't afford that, there can be some issues. So I tend to tell people, if at all possible, keep it the same person, because sometimes you can have competing decisions. Either way, I tell people, make sure you talk to your family about this. This is a family decision. These are major family decisions. I always tell everybody, when you do a power of attorney, make sure that the person who's going to be your power of attorney knows about it. The last thing anybody wants is a call from a hospital going, hey, mom or dad, gave us this power of attorney, and we're calling you to make the decision, and it's just a whirlwind of emotion, and you had no idea. So I always tell people, talk to everybody ahead of time. Before you come in to meet with the attorney, make sure you talk to whoever you're going to list, whether that's a brother, sister, son, daughter, whoever it may be. Make sure that they're on board, that they are mentally and physically ready to make those decisions for you. And also, it's not a precursor for power of attorneys. I usually tell you, pick somebody who lives fairly close to you. And, I would want somebody who's knowing how I'm living, can actually stop by, see how I'm doing. If I'm living in an assisted living facility or a nursing home, I want somebody to stop by and make sure I'm getting the level of care I need. Like I said, it's not, a be-all, end-all. You can't be a power of attorney, but that's a personal decision, and how comfortable are you with that? You need to make sure you have somebody who has the time to pay your bills. I know personally, I'm short on time and can barely pay my own bills. So, I would want, somebody, who's got a little bit of extra time, maybe doesn't have a bunch of small kids running around, so they can focus on the care you need, for yourself, and can also make sure you're getting, everything that you need. All your bills are paid. They're taking good care of you at the nursing home. So some of the major differences, just to point out again, is guardianships are, created by the court when there's a need. So typically a guardianship is, somebody's had a stroke, or I once had a case where, somebody passed away and they were the caretaker for the ward, and now they need somebody. But there's always a need. The person is in need of somebody to make decisions. Powers of attorney are made well before that. And I tell people to come in before there's an issue. You don't want anybody, the last thing you need is when, stuff's happening, is somebody to claim that it was made under duress, or you didn't knowingly, voluntarily, intelligently make the power of attorney. Guardianships are involuntary. So you don't get to choose who's going to make those decisions. The judge is going to make that. Some people are okay with that. Some people are not okay with that. But you don't really get a choice as to who is going to make those decisions. Like I said, it can be an attorney, it could be a son, daughter, niece, nephew, anybody. With the power of attorney, it's your decision. You decide, who is going to make those decisions. You know best. With powers of attorney, they are easily modifiable. So, like I said, maybe your power of attorney when you're 20 may not be your power of attorney when you're 60. With guardianships, they're not easily modifiable. It's usually one guardian until that person can't or won't do it anymore, and the court's not going to change it very often. And obviously, the ward does not get to change it. With guardianships, there's a lot of court oversight. Like it said, you've got to file yearly reports. You've got to give the court updates on the person's health. You've got to ask for court permission to spend money. With powers of attorney, there's very little court involvement unless somebody takes you to court and says, hey, I don't think this is being done correctly. So, like I said, there's a lot of trust that has to be there for a power of attorney. So, the question I get from people after going over all of this is, well, geez, I clearly want a power of attorney. Guardianships, there's all kinds of time and hassle. Guardianships are a court process that costs thousands of dollars to go to court, and we're litigating over. And, powers of attorney, they're fairly quick, relatively cheap depending on who you go to. I can modify them. I can choose who I want to be my power of attorney. For a lot of, so you may be sitting there going, what's the downside of a power of attorney? Well, this is one of the things where you need to sit down with an attorney, because you hear all these great things about it, but there's a lot that goes into it. And so, big disclaimer, before you make a decision about what you want, I highly, highly advise you to sit down with an attorney and go over all of your options and all your family's situations to see what's best for you. So my answer to that question is maybe. There's a lot of questions here we need to answer. So the first one is when I get that call, is the person who needs the power of attorney capable of making decisions? Like I was saying, so often people don't deal with this ahead of time, and I get a call that mom or dad, just had a stroke and they're in the hospital, and they're suffering from late stage dementia, and they need a power of attorney. Well, I may agree that they need a power of attorney in that situation, but the reality is that you have to voluntarily make that power of attorney, and you have to know what you're making, and you have to be able to know who you're giving that power to. And, if you're not able to, then we can't go the power of attorney route. And that's where you see a lot of your guardianships, is where people don't have these documents in place. Another big one that we really look at here on the attorney side is there any undue duress or undue influence here? So if you ever schedule an appointment to come in and meet with me, for your mom or your dad or anything like that, I will always have children or whoever is not getting the power of attorney. I have them sit out in my waiting room. I am generally only meeting with the person who needs the power of attorney. I want to make sure that the decisions that are being made are actually the will of the person who is making them. And so I typically actually schedule 2 or 3 meetings with people. One to say, okay, who do you want today to be your power of attorney? And then I'll draft them, and then I'll bring them back, and we'll do the same thing where the people who may be the power of attorney aren't in the room meeting with us. And I've actually had situations where the client has said, Mike, I don't want this power of attorney right now, or I don't want this person to be my power of attorney anymore. So that's why I kind of like that waiting period or cooling off period. And actually, I don't even charge people at that point. I want there to be absolutely no duress, no undue influence. I don't want anybody to think that, man, I've got to do this power of attorney. Maybe Mike's charging me for it. No, I don't even charge you. I won't tell your family members. I'll give you the documents you want, or if you don't want any of the documents. We want to make sure that this is your choice, that this is your decision in this matter, and we don't want anybody else, influencing that whatsoever. And then, there are two other questions here. Are there assets that need to be managed? That, in certain cases where somebody already has a Social Security payee, there may not be a need for a power of attorney. Now, again, that's a rare circumstance, but it's becoming more and more common with people who are in Medicaid situations where the facility where they're living at, nursing home, assisted living facility, may already be receiving all of their money. And so if there's no assets that need to be managed, then you may not need a financial power of attorney. And then, are there medical decisions that need to be made? And who are going to make those decisions? Do you want people to make those decisions? So, sooner or later, there may not be medical decisions right now that need to be made. You're young, you're healthy, but later on down the road, there may be medical decisions that need to be made. And then if you answer those questions, yes, then we get to, the next question is, okay, we're definitely thinking about powers of attorney, but this, one of the biggest questions right here is there anybody you trust to make those decisions? And, I've had people where they go, Mike, I really want a power of attorney, but honestly, my son's got a couple felonies, and, my niece or nephew's had a couple foreclosures or bankruptcies. And if the answer is no, then maybe, waiting and seeing if you need a guardianship is the, right thing to do. Because like I said, there's a lot of power when you give somebody power of attorney. There's a lot of trust in there. There's not a whole lot of oversight. It's a rare circumstance where somebody, finds out that assets are being depleted. Bank accounts are pretty quiet. And what happens when you have a power of attorney set up is that generally it's the power of attorney who's getting the bank statements, and the bank is only going to talk to you or the power of attorney. And so other people are generally left in the dark in these situations. And so, the only time that we tend to see it is after somebody has passed away, and then there are allegations that, the power of attorney abused their, position, and now we have an executor who's going back and they're looking at everything and they're going, okay, maybe there was an issue here. So, but that's after you've passed away. Another big thing to consider is how close does the person live that you want to make these decisions? Again, this is a personal decision, but, I typically would want somebody who can make sure that my daily needs are being met, that the decisions I'm making are the best decisions for them. And you can't always do that from 3 or 4 states away. And so that's something that you may really want to consider. Again, it's not a requirement that they live in the state of Ohio, but I generally, recommend that you look at that. And I have a few where they can manage it from, out of state. Now, like I said, the big thing is if you decide to move, I would definitely recommend talking to a new attorney in a new state and getting new documents. And then the last, and probably one of the most important questions is you need to talk to your family members or whoever you're listing as your power of attorney, and do they want that power? So it's, do they have the time? Like I said, they could be a busy parent with 4 kids and soccer practice, and they just may not have time to, talk to doctors and manage all your finances. It may be, this is very common, especially with healthcare powers of attorneys. Like I said, oftentimes in there's a living will, and the very, very tough decisions about when to make end-of-life decisions. And do you use artificial nutrition and hydration? When do you take mom or dad? When do you pull the plug on them? And that's a very, very tough decision, and not everybody can make that decision or wants to make that decision. So, you want to talk to your family or whoever you trust ahead of time, and you want to sit down and make sure that they are on board with doing this for you. That's the last thing you want, is someone surprised that you've made them power of attorney and they only find out once there's an emergency. And now you may have a power of attorney in place, but you have somebody who may not want to do it, and so then you may have to look at a guardianship depending on how you set it up. So that may be one of the situations where, okay, this person is a power of attorney, but they don't want it. And then if they don't want to do it, then you got to look at the alternative. And that's why it's always important to update these regularly. Like I said, somebody, may be in one position today, and 5 years from now, they may be in another position and may not be able to assist you the way they did before. So it is so important to regularly meet with your attorneys, and financial advisors to make sure your needs are being met. And so some major things I tell people to avoid is complacency and doing it yourself. So complacency doesn't mean always doing a power of attorney, as you've seen here today. Complacency means avoiding the topic. And that's the worst thing you can do. Because at least if you have that conversation with your family, hey, you know what, I've decided, I love you guys, but I would just feel more comfortable if there was court oversight, so there aren't any documents, in place. Or, if you do decide, you know what, we do need to do these documents. And, you make sure they're on file with, it takes a while, because I usually tell people put them on file with your banks, your retirement plans, your doctors, your hospitals, and make sure the people who are going to be your power of attorneys, know about this. And oftentimes I recommend people, if you have multiple children, tell you the kids that you didn't choose. Explain to them that, listen, Johnny is in a better position right now to make these decisions. It's not that I don't love you or anything like that. It can oftentimes help with that process, because what you can see on the back end is that, one of the kids feels slighted, and then they start second guessing everything, and then that leads to people filing stuff, opening up guardianships, and really can cause rifts in families when, there's a lot of complacency, and then people aren't talking, and then they're assuming things. And it helps prepare your children for this. It helps prepare them, okay, I'm going to be the person to manage the finances. I'm going to have to make these medical decisions. And when we're talking about these end-of-life decisions, that's a great time to have a talk with your family and say, you know what, these are my wishes. Take that burden off of your children, your spouse, whoever it may be, and say, this is what I want in this situation. So, yes, you're going to be the person who says it, but this is the way I want it, and I'm going to be okay with it. And like I said, the worst thing to do is do it yourself. It's very, very tempting to go online or buy a program or anything like that and do it yourself. I've had people walk in here to my office and say, well, geez, I could, you guys just fill out forms, don't you? No, there's a lot to it. Just to give you guys a quick warning, I had a case a few years ago where they did just that. The daughter was a notary, and, she ended up, finding a power of attorney, and they did a financial power of attorney for dad. Dad did a transfer on death on his house, but they didn't do it correctly. And so it ended up that the house, did not go to the son like they wanted it to, and ended up in foreclosure, and it was just a mess. There are, a lot of risks inherent in everything, so I would highly advise anybody who's thinking about it. Power of attorneys are not very expensive generally. I said, you schedule an appointment here at my office. It's a free initial consultation, and then we kind of go from there with, what direction you need. So what I tell everybody, the next steps in this is take a look at your situation. Sit down with your family and say, okay, what do we need today? Where am I at in my life? Do I have 3 small kids of my own? And so maybe I need to talk to my brothers or sisters about being a possible power of attorney. or in my 60s or 70s, and so maybe we have grown kids. Sit down and see who's comfortable with this, who has time to do this. And once you've sat down with your family and had this conversation, contact an attorney and sit down with them and talk about your options. Never hurts to talk. And then you can decide what's best for your family. Is it the guardianship route or is it the power of attorney route? So while I maybe answered some of your questions here today about guardianships and powers of attorney, I really hope that you took from this that it's time to sit down and look at your finances and look at what do I need to do to make sure that my bills are paid, make sure that medical decisions are made for me, and that my family is taken care of, my assets are managed properly, and that you reach out to an attorney, to help you make the decisions that matter to you. So I'd like to thank you again for attending here today. If you have any questions for me, please feel free to reach out to me, schedule a consultation and come in and talk about your situation, or email me there if you've just got a quick question that you need answered. But I would, really be happy to talk to you. I thank you guys for taking the time to attend the Portage County Financial Wellness Fair. I highly encourage you to watch all the other presentations, and I wish you guys the best of luck.